Okay, let's get started. And once again, welcome. And thanks for joining today's session. Anxious heirs calling your office for their inheritance, how ProbateCash can help. A webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. Mark will address questions after the presentation. If your question is case-specific and confidential, please indicate that in the chat, and someone will respond separately after the presentation. Our presenter today is a professional with extensive experience in the probate field. Marc Harris is an attorney admitted to the Florida Bar in Southern District of Florida. Marc is also a member of the Florida Bar's Real Property, Probate, and Trust Law section. Marc has been working in the specialty finance industry for over 25 years and involved in the purchasing of over $100 million worth of assets. Many of those purchases, pursuant to various state laws, require court hearings, many of which Marc has either attended or appeared as counsel. As the CEO of ProbateCash, Marc is now spearheading a relatively new industry of purchasing interest in actively pending inheritance claims from estates or trusts. Okay, so now without further ado, let's hear from Marc. Marc, can you start us off with what ProbateCash does?
Sure. Thanks, Molly, and thank you all for attending this webinar from all over the country today. So it's good to have everybody for what will be hopefully informative type of infomercial. I've spent most of my career providing upfront liquidity to people who've been waiting for their future cash flows. And the cash flows vary, all sorts of cash flows. And with probate, I've had a lot of friends who are probate attorneys. I'm a attorney, as Molly said, and a member of Florida's probate section bar. And my friends and colleagues are constantly receiving phone calls from people who are frustrated and want their anxious heirs, as our title would suggest, to receive their inheritance. A lot of people, lay people, as you guys probably know, really think that they receive their inheritance like they do on television. Somebody passes away and they go to the lawyer's office. There's some reading of the will and some car keys are handed out and some house keys and some cash, and everybody goes their merry way. That, of course, is not the way probate works. In reality, they're going to the bank and they're going to call realtors to sell property, and they're learning for the first time that they need something called letters testamentary. They're learning that they need something called probate before they can actually even reach the assets of the estate. That's when they call you guys. So then they call the lawyers up to open up probate and learn not only do they not are they unable to get their money right now, but this probate process can take many months, if not longer, depending upon each situation of each probate case. That's what we do. We fill up that void. So for those people who need money now, we provide them with non-recourse advances today, and we wait until the estate assets are ready to be distributed by order of the court before we get repaid. Now, we can get repaid at any time, but we know, practically speaking, we're usually going to get repaid at the end of the probate case.
Okay, so now how does an advance from ProbateCash actually work?
Sure. So it's a pretty simple process. We can talk directly to the beneficiary. We always talk to the estate attorney. We always want to keep the estate attorney in the loop, ask a couple of questions just to make sure that we're dealing usually with at least the right people. Like purchasing any asset, we want to make sure that the person we're talking to is actually, one, a beneficiary of the estate, two, entitled to an inheritance, and then three, whether the estate has assets, so they will actually receive some of the inheritance. And so we're just trying to get the basics at that time. We provide a very simple application, not a loan application, just an application with a case number, some information about the estate. Our office has paralegals who act as /underwriters who then look at the cases. We're looking to see what stage the probate case is in, because we give advances throughout the probate. We can do it before letters are issued. We can make advances during the claims period. So at all stages, those are the risks we take. That's the nature of our business. Once we're able to determine that the beneficiary is indeed a beneficiary and the right identity, and we look at the stage of the probate case, we make a decision of how much that person would qualify to receive as an advance. Our goal is to always keep the beneficiary engaged in the probate process. So we do not purchase the entire inheritance or what we think will be the inheritance. And you never really know what somebody's going to fully receive, but we want to just purchase a portion of the inheritance and keep our customer engaged in the final result, which is seeing the probate through the entire court process.
Okay, now you mentioned funding in advance, I think in as little as 1 to 2 business days. How can Probate Cash fund in advance so quickly?
So I mentioned what we do in these non-recourse advances. I didn't mention, want to be very clear what we don't do. Probate Cash is not a lender. So when we're making these advances, I'm not interested in a beneficiary's credit report. I'm not interested in their collateral. I'm not interested in making sure they can pay us back every month with some set payment term at some set interest rate. I'm just interested in knowing that they're a beneficiary of the estate and that they're going to receive some sort of inheritance, or we hope they're going to receive some sort of inheritance at the end of the probate process. That's all we need before we make a decision to make an advance. Now, I will do a search and make sure the beneficiary doesn't owe child support or anyone else who could intercept the inheritance potentially who may have rights. But otherwise, because we're not a lender and there is no loan application process, we can get to a result very quickly. So these advances are great for people who need money right away, who wouldn't qualify for a loan, or who potentially could qualify for a loan, but they don't have the time to qualify for a loan. Maybe the need for cash is imminent.
Okay, now I think we already touched on some of these, but what are the pros and cons of an inheritance advance?
Sure. So the pros are easy, but obviously these questions are set up in advance, right, Molly? And I always want people to know the cons of advances too. What could go wrong? I want to make sure that everyone's very informed of this process. So quickly, the pros. What the first pro is we have access to immediate cash. So beneficiaries need that money just to live for their daily needs often. Second, the estate often needs money. Why? Because taxes may be due on the estate property, or you have an estate property that with $25,000, $50,000 of repairs, it could resell for $100,000 to $200,000 more of money as opposed to what maybe a cash buyer is offering. That kind of money benefits all the beneficiaries of the estate. So that's a pretty obvious pro as well. Um, Third pro, which is indirectly for you guys, is somebody who receives money from us isn't going to be constantly calling your office anymore for saying, when is this going to close? When am I going to get my inheritance? We've bought a little bit of time with that. And when they contact us, we also will stay, we will be following as well. I said we had underwriters, we'll be following the case, and we can update those beneficiaries with what's going on in the case so they don't have to be calling your office. The cons, what are the cons? Our money is expensive. And so the advances, our fees start at 25% of the advance amount. So if somebody takes a $10,000 advance, they're going to have to pay us back the $10,000 plus a fee of $2,500. And that's where it starts. It goes up from there depending upon when we get paid back. So this isn't the kind of money that I would tell people to receive in advance if they wanted money to take their kids to Disney World. Yeah, this isn't for luxurious items. This is for helping with estate assets, helping for somebody's needs, really not to be used as an ATM. And so I always caution beneficiaries to either talk to their advisors or to make sure they have no other means of raising funds, which most people don't who come to us, and that's why we're here. So I also care very much that our customers understand the transaction. So even though our contracts are painfully done to avoid as much legalese as possible, and on top of that, when we are before we're ready to send the money to our customers, we do a recorded phone call with them and go over the terms of the advance and repayment terms. And so we do that on a recorded call as well to make sure that they are making a very informed decision.
Okay, now circling back to the title of this webinar, how can ProbateCash specifically help law firms?
Yeah, so that's hopefully one of the reasons we're in business, or hopefully that's one of the results of us being in business. Is I'm an attorney, as you know. I'm married to an attorney. I have the utmost empathy and respect for lawyers. So one thing I know is that lawyers are marketing themselves like anybody else, and in getting that marketing, they're then hopefully it's working, and they're getting a lot of phone calls. Now, in probate, people who are calling you were probably first trying to access those bank accounts that they were told they can't get without opening up a probate case. So not only are they not able to receive money, but now they're being told they have to pay retainers to you. We've worked with a lot of law firms around the country who have those issues where they want to receive a retainer, but their clients don't have it. What we'll do is enter into a contract with the beneficiary who's calling you, have that beneficiary authorize us to pay the money directly to your firm as a retainer to open up the probate. So if your retainer is $5,000, we'll enter into an agreement to make a non-recourse advance to a beneficiary for $5,000, and that beneficiary would authorize us to pay you, attorney, the $5,000. Now you have your retainer and you can open up the probate case. All we're looking for in those situations is we really want to confirm there's real property, which is the asset of the estate, and that property is going to be sold. So we're also, as you know, what are the issues that can come? And I'm talking to knowledgeable folks on this call. Is somebody living in the house? How are they going to move? Is there going to have to be an eviction? Those are often the unpleasant issues or time-consuming issues that take place in a probate. We're aware of that as well. We deal with that every day. But what's important is you guys are getting paid so you can start working on the probate cases as well. And so we can make those advances right there. That is to directly to your firm for your retainer. That's an incredibly direct benefit to law offices. And then we've touched on the indirect ones, and that's making the noise stop from other beneficiaries who are asking for updates. As I say, we update them with the cases as well. Finally, being an attorney myself, I make sure that everyone in my company knows to talk very highly of the probate attorneys. We always say what a good job you guys are doing. We know delays are not your fault, and we make sure that we definitely send that message, convey that message to those beneficiaries. So that's we have the utmost respect for what y'all do, and we pass that on and never say, "Oh, it's the attorney's fault." So, and I think as part of that, that recorded call I referred to as well, just additional protection that you guys should know about of the care that I take to make sure that everybody understands the transaction.
Okay, now how does an advance to one beneficiary affect the other beneficiaries who are not assigning portions of their inheritance? And how does an advance affect the probate case?
Yeah, so this is important also for the lawyers out here. Most estates have multiple beneficiaries, and oftentimes only one beneficiary needs an advance, sometimes multiple. And when one beneficiary needs an advance, we only enter into contract privity with that beneficiary. It has no effect on the other beneficiaries. Remember what our business is. We're only purchasing an assignment of the inheritance. We're purchasing a portion of the inheritance from the beneficiary. What we're not doing is becoming a creditor to the estate. So we're making no claims against the estate, and there's no reason at all that the probate case would be inconvenienced by our involvement of making an advance.
Okay, now can multiple beneficiaries get an advance from probate cash?
Absolutely, and that's often the case. As you can imagine, one beneficiary takes an advance from us, spreads the word. Another beneficiary say, yes, it's been 3 months going on and there's still no end in sight, or 6 months or 9 months, whatever it may be. And so, yes, multiple beneficiaries can make assignments, and we will just, again, like once the estate is ordered to repay, we'll have the personal representative who can also take an assignment if they're a beneficiary, pays us back from the estate assets.
Okay, now are there any laws that govern inheritance advances?
There are actually. So this is a pretty new business, but the laws are starting to catch up, which we like. More regulation is better for everybody. California was really the pioneer state of all states in drafting legislation, and that's California Probate Code 11604.5, 11604.5 of the California Probate Code. Utah recently just passed a law that is almost the same as the California statute, and the Utah code, probate code, is 75-3-918. That's 75-3-918 of the Utah probate code. And as you can imagine, the probate code is for these statutes are very consumer protective oriented, which they should be. So there's the it goes so far as what font our contracts can be in. Make sure they're easy to read, no hidden fees. The kind of things that you would want to protect people who are probably not as sophisticated potentially, and common sense laws in those states. And so, let's say that we're not in California, we're not in Utah, but we're in one of the other 47, 48 states. In those states, we do business. And what I do is I use the same form of contract that California law requires, Utah law now, and follow the spirit of that statute. And we actually, when there is an assignment, we file the assignment with the probate court. So everybody has notice of the assignment. Because we want the personal representative, first and foremost, to know that to pay us when the estate comes due. But the court knows it as well. So there's nothing that is going on that is not 100% transparent. Everybody sees that there's an assignment going on, and who gets repaid. It's pretty well, it's fully transparent, and it should be easy to follow.
Great, thank you, Mark. Wow, I think we're already past a little the 15-minute mark, and as promised, Mark is going to stay on to answer your questions. But if you need to leave now, we're going to send everyone a link to the recording of the presentation and the questions and answers. Also, if you have any questions you'd like to ask offline, you can call Mark at 561-476-0018 or email him at Marc, and it's MARC, at probatecash.com. But now, without further ado, let's get to your questions. Okay. It looks like the first one is, just to be clear, as their attorney, how can I help my client qualify for an advance?
So, as an attorney, how can you help qualify? Yeah, I said before, if you may have joined us late, but we're going to call you as the estate attorney and just ask for a little bit of basic information about the estate. We're not asking you to play fortune teller to tell us, don't worry, for sure the money will be there. There's no way claims are going to be filed. We know you can't see that. But we're just going to get a little bit more information about the property, people living in the property, the intent to sell the house. Are there beneficiaries to accounts, or are those accounts estate assets? Whether you know that at this point, just whatever you know. We're trying to make the most informed decision, and the more information we have, the quicker we can provide the advance to the beneficiary.
Okay, now as an attorney for an estate, can I be held responsible if I talk to your company about an advance, or if I don't get repaid? Or if you don't get repaid? I'm sorry, misread that.
Well, I think if we don't get repaid, no. As I said, these are non-recourse advances. We have no recourse against anyone for advances absent fraud, right? That's just stealing. But we ask lawyers every day for information about the estate. And I know as lawyers, we're all paranoid about what we provide. Nobody wants to give too much information that it's going to be legally relied upon. We're not legally relying upon anything. We're not asking the lawyers to sign anything. I would go so far, though, that it is a lawyer's responsibility to know that our service exists, because beneficiaries who are calling you and who really need money should have the option to determine if this is right for them to receive in advance. And if they don't have that information, then lawyers probably aren't helping, they're not counseling their client or beneficiaries like they should as counselors.
Okay, now this one is, can you get an advance before the probate case is open?
So yes is the answer, and we alluded to that with, in fact, advances to pay retainers fees, because the probate case surely wouldn't have been opened at that time. So again, we're looking for real estate as an estate asset. Just to be very clear, though, we must have a decedent. So yes, before the probate case is open, but after somebody has passed away. So you got to have a decedent as part of this transaction. And we're not in the insurance business where we're trying to handicap when someone is going to pass away. This is a post-passing event.
Okay, that makes sense. Here's another question we have here. It says, I represent the plaintiff who is challenging their heirship. Do you make advances into adverse cases?
So that's an interesting one. We have quick answer is yes. And if you have those kind of cases where you're representing somebody who's making a challenge, or who they may have been disinherited, or there's undue influence, the usual reasons that you see in there. I urge you to call me. The information Molly gave, 561-476-0018, or Marc and MRC at probatecash.com, and we can discuss that. We've advanced many hundreds of thousands of dollars in adverse situations where there's litigation or potential litigation in those situations. But those are one-offs. But yes is the answer. We
Mhm.
have done that, and certainly happy to discuss those circumstances as they arise.
Okay, great. I'm going to pop over, make sure we have everyone's questions answered. It looks like we have got to everyone's questions. But if you think of anything else, or if you're like me and you think about it 10 minutes later, we will be sending out a follow-up email with a link to this webinar. Also, if you want to contact Mark directly, you can call him, as we've said, at 561-476-0018, or email him at Marc, and that's MARC, at probatecash.com. And thank you so much for joining us, and have a great day.
Thanks.